All right, let's break down a really crucial topic, not just for anyone interested in Indian law, but especially for all of you UPSC aspirants out there. We're talking about the 5 powerful writs under Article 32 of the Constitution. And trust me, these aren't just some dusty legal terms. They are your most powerful tools for protecting your freedom. So, just imagine for a second. Your fundamental rights, the very bedrock of your liberty, are violated. What do? Where do you go? Well, the Constitution itself gives us a very direct, very powerful answer.
And that answer is Article 32. This gives every single citizen the right to go directly to the Supreme Court if their fundamental rights are messed with. And get this right is so important that it's a fundamental right in itself. It's often called the right to constitutional remedies.
So how does the Supreme Court actually enforce these rights? It uses a special tool called a writ. Now, the easiest way to think of a writ is as a formal written command from the highest court in the land. It's an order to set things right. There are 5 different types, and knowing what each one does is absolutely key.
Okay, first up, we have the big one, the absolute cornerstone of personal liberty, habeas corpus.
The name itself, from Latin, literally means to have the body. And its whole purpose, its entire reason for existing, is to act as a powerful shield against anyone being illegally detained or arrested.
For example, the law is crystal clear. A person has to be brought before a magistrate within 24 hours of being arrested. If that crucial deadline is missed, the detention instantly becomes illegal. The police simply cannot hold them any longer without an order from a magistrate.
And the process itself is very direct. If the person who's been detained can't file the petition themselves, which is often a case, their family or even their friends can do it for them. The court then looks at the reasons for the detention, and if it finds it's illegal, it orders the person to be released immediately.
And here is what makes it so incredibly powerful. It doesn't just apply to public authorities, like the police. It can also be used against private individuals. So if one person illegally confines another, this writ can be used to set them free. It covers all bases.
All right, let's move on to our second writ, which is Mandamus. This one protects our rights from a completely different, but equally important angle.
Mandamus. Again, the Latin name tells you everything you need to know. It means we command. It's basically an order from a higher court telling a lower court, a tribunal, or any public authority to do the job they're supposed to do. So let's say you need a license to start a business. That's part of your fundamental right to practice a profession under Article 19. But the official in charge just won't issue it. Maybe they don't give a reason, or worse, they're hinting at a bribe. Well, mandamus can be used to command that official to perform their duty.
But, and this is super important to remember, especially for your exams, mandamus has its limits. It only applies to public duties, so you can't use it to, say, enforce a private contract. It also can't be issued against high-ranking officials like the president or for duties that are discretionary, meaning duties they can do but don't have to do.
Okay, now let's look at 2 writs that kind of work as a team to keep the judicial system in check, Prohibition and Certiorari. Now, these 2 often get mixed up, so let's clear up the confusion once and for all. Think of Prohibition as a stay order. It's purely preventative. It's like a giant stop sign from a higher court to a lower court. If a lower court starts hearing a case that it legally has no business hearing, it's outside its jurisdiction, this writ stops the proceedings right in their tracks.
Certiorari, on the other hand, is mostly curative. It's more like an undo button. It's used after a lower court has already made its decision. If that decision was wrong, maybe because of a lack of jurisdiction or a serious legal error, the higher court can step in, review it, and completely quash or cancel the order.
So let's put them side by side. It makes it super clear. The biggest difference is timing. Prohibition happens during a case to stop it. Certiorari happens after a case to fix a mistake. Now, while Prohibition is purely preventative, Certiorari is both curative, it quashes an order, and it can also be preventative because a higher court can use it to transfer a case to itself before a judgment is made. All right, our final writ is a really powerful tool for keeping our public institutions honest. It's called Quo-Warranto. And again, the name says it all. Quo-Warranto literally means by what authority? This writ is used to challenge a person's legal right to hold a public office. It essentially asks them to prove they belong there. So why would you need this? Well, imagine a public office gets filled, but there was no proper advertisement, no fair selection process. This is a direct violation of Article 16, which guarantees equality of opportunity in public employment. This writ allows you to question the legality of that appointment.
So, a few key things to remember here. This only applies to a public office that's permanent and created by law, not a private or temporary one. But here's the most important part. Any interested citizen can file this petition. You don't have to be personally affected by the appointment. This makes it a huge tool for public accountability.
So we've gone through all 5 writs, but a really practical question comes up. Where do you actually go to file one? This is a key detail, especially from an exam perspective.
This is a classic exam question, so listen up. You've got 2 main options. Article 32 is your direct line to the Supreme Court, but it's only for violations of fundamental rights. Now, Article 226 gives high courts an even broader power. They can issue these writs not only for fundamental rights, but for the violation of any other legal right as well. That distinction is so important.
You know, when you step back and look at all 5 of these writs together, you realize there's so much more than legal jargon. They are the living, breathing mechanisms that turn our fundamental rights from just words on paper into enforceable realities. They truly make the judiciary the ultimate guardian of our rights.
So I want to leave you with this question to think about. As our society keeps evolving and we face new kinds of challenges to our freedoms, which one of these 5 powerful tools do you think is the most essential for us today? Is it the shield against illegal detention, the command to a public servant, or the power to question authority?